Well, hello everyone, and welcome to another edition of Straight Talk. Thank you very much for joining us for today's webinar. Today, we're very fortunate to be hosting Judge Thomas Griffith, who recently retired from the U.S. Court of Appeals for the D.C. Circuit. The event will be webcast live, and the full video will be available online in the coming days. And I just want to remind you, as I'm sure we will again, to put questions in the chat, and we will try to take as many of your questions as we can, because I think this is a rare opportunity to hear from somebody of Judge Griffith's stature. And with that, I will turn it over to my partner in crime, David Hill, who's the one who knows and lined up the judge, to introduce him and kick this off.
Thank you very much, Cheryl, and again, welcome everybody this afternoon. It's my privilege and pleasure today to welcome former U.S. Court of Appeals Judge Tom Griffith to today's session of Columbia Energy Straight Talk. Judge Griffith served on the U.S. Court of Appeals for the District of Columbia for more than 15 years. He was appointed by President Bush in 2005 after being confirmed by the Senate in June of that year. I'll just say that the vote on him was 73-24, I believe. And I'll note as an aside that 3 of the senators who voted to confirm you, Judge, were Barack Obama, Joe Biden, and Mitch McConnell. So there you go. Judge Griffith retired and stepped down from the bench in September 2020, so just a little bit over a year ago. Before joining the court, Judge Griffith had a distinguished career in both the private and public sectors. Immediately before joining the court in 2005, he was the general counsel of Brigham Young University in Utah. And before that had been Senate legal counsel and a partner at the Wiley Ryan Fielding law firm in Washington, D.C. He received his undergraduate degree from Brigham Young and his law degree from the University of Virginia. And most recently, he has served on the Presidential Commission on the Supreme Court, which President Biden appointed earlier this year. He's a special counsel at the Hunton Andrews Kurth law firm in Washington and is a panelist with FedArb as well. I'll also note before I get to my first question that Judge Griffith and I have known each other for almost 30 years. We were associates together at the Wiley Ryan law firm back in the 90s, and in fact worked together on some cases together. Judge, that's a long, long time ago now. We've stayed in close touch through the years, and I think very, very highly of the judge. So, Judge, welcome to today's session of Straight Talk. It's a real pleasure to have you and have you join Cheryl and me today.
You read that introduction just as I wrote it. Thanks.
We're very, very happy to have you. So my first question concerns your former court, the U.S. Court of Appeals for the D.C. Circuit. That court's really unique. Even though there are 13 U.S. Courts of Appeals in the country, the D.C. Circuit is uniformly regarded as the second most powerful court in the United States, really second only to the U.S. Supreme Court. For the benefit of our audience today, maybe you can just describe, if you would, your former court and why it's unique, and maybe talk a little bit about its jurisdiction and the kind of matters that the court handles and that you handled while you were there.
Sure, thanks. Well, first of all, let me say that there's no member of the court that feels comfortable with that description that the media always gives. I don't. All of our mothers are comfortable with it and love it, but none of us is, and I really don't know what it means. Is it the coaches poll or the sports writers poll? I mean, how do you figure this out? No, it is, but it is distinctive. It is unique. It has a unique history. Congress has paid a lot of attention to it over the years and its jurisdiction, and its membership is a little bit different. So let me talk about its membership first. The fact that it's the Federal Court of Appeals in Washington, D.C. is highly significant because there are no senators in Washington, D.C. And so therefore, while Senate confirmation is still required, over the last 30, 40 years or so, the D.C. Circuit has become sort of the special purview of the White House counsel's office. And so the White House has an outsized influence in the nomination of members of the court. And we've seen that used by several presidents to use the D.C. Circuit as launching pad for a later nomination and then appointment to the Supreme Court. Justice Kavanaugh, Justice Thomas, Justice Scalia, Justice Ginsburg, Justice Berger. I hope I'm not forgetting anyone, but that's a bit distinctive. That's a bit unique. So maybe that may be one reason the media pays such attention to the DC Circuit, is the unique personnel on it. But the real reason, the way it's really different for lawyers, not just for politicians, is that it does have a unique docket. I don't, somebody keeps track of these numbers. I don't, but it's something like 60% or more of the cases in the DC Circuit involve the federal government as a party in one capacity or another. And a good deal of those involve challenges to actions taken by administrative agencies. So over the years, over the last 50 years or so, the DC Circuit has developed an expertise in administrative law that makes it a little unusual. There's some other things that are unusual about it. I mean, it's the smallest circuit in terms of geographic footprint. There's some business activity that takes place in Washington, D.C., but nothing compared to the amount of business activity that's covered by the other circuit courts. So not that many of the cases before the D.C. Circuit involve the sort of commercial disputes that you see in lots of other courts of appeals. It's heavily weighted to administrative law. I think I read an article a couple years ago that in one of the Cornell journals. They went through every provision of the United States Code to see how the DC Circuit was referred to. And there's something like, I think it's something like there are over 40 provisions of the US Code that assign exclusive jurisdiction of disputes to the DC Circuit, and then 130 that allow concurrent jurisdiction. So over the years, Congress, for a certain category of cases and types of decision makers, has paid special attention, has said we want those cases in the DC Circuit. The exclusive jurisdiction cases tend to fall into three general categories. Administrative rulemaking, a disproportionate number of the jurisdictional provisions for review of agency rulemaking call for exclusive jurisdiction in the DC Circuit. Decisions by independent agencies, a disproportionate number of those jurisdictional provisions are assigned to the DC Circuit. And then sort of a bucket that I'll call cases of national impact, foreign relations, these sorts of things. There are many statutes that assign exclusive jurisdiction to the DC Circuit. So that's I think the heart of the matter is that it's so many of our cases involve the federal government in one capacity or another.
You know, Judge, you the judges on the court, you of course had been the general counsel at BYU immediately before you joined the court. You'd practiced in Washington. Some of the other judges on the court have had a whole variety of different experiences around the country and different things, as opposed to some of the other U.S. courts of appeals in the country where generally, I mean, not exclusively, but generally the judges have practiced in that area where they wind up on the Court of Appeals, and a number of them in different courts of appeals have been former U.S. district judges, U.S. magistrates, things like that, which seems to be far less common, on the D.C. Circuit. Do you think does that affect how the court operates? Is that your sense in any way, or does it?
The one thing that's different about it is that they come from all over the country, and that's a reflection, I think, of not having any senators in Washington, D.C., right? I mean, at the time of my appointment, I was from Utah. I'm actually from Virginia, but I was living in Utah at the time. Janice Rogers Brown was appointed at the same time I was. She's from California. The most recent of the two most recent appointees, one is from D.C., Judge Jackson, and the other's from Kentucky, Judge Walker. So there's more regional diversity, and that's because in Congress and in creating the court, it's the only federal court of appeals, federal circuit court, that does not have a residency all the others do. The DC Circuit doesn't, and that was intentional. The idea was to try and make it more national in scope. In terms of background, no, we actually do have a number of judges on the Court of Appeals who have been district court judges. I'm thinking of three. Judge Walker was a district court judge. Judge Santel from North Carolina. Judge Henderson from South Carolina. But others have commented that a disproportionate number of judges from the DC Circuit have had significant experience in the federal government in one way or the other, largely from the executive branch. Mine was from Congress, and I get some ribbing about that from my colleagues a lot. They assumed I was an Article 1, that I favored Article 1 over Article 2. But a lot of judges on the DC Circuit have had rather significant experience
Well, Judge Griffith, we've talked about sort of some of the scope of what you did, which is kind of daunting to me when I think about all those agencies and all those provisions of code coming in. As you know, I used to be at the Federal Energy Regulatory Commission, one of your feeder agencies, and we thought we had a lot trying to keep track of electricity and gas and hydro and oil and so forth. But I mean, you just had such a breadth of topics that came up to the circuit. So how did you, when you got a big, gnarly, complex docket with all the technical, how did you and your clerks go about unpacking it? I mean, because you don't specialize in one thing, right? You might have something about telecom one day and something about some drug provision the next day. How did you approach those dockets?
Well, that's a great question, Cheryl. And at first, my first couple of years on the court, I thought that was a bug in the system. I kept thinking, this would be handled so much better if you had some specialists who knew this area of law and didn't have to keep looking at Black's Law Dictionary and just Webster's Dictionary and reading background papers. Wouldn't it be much better if you had specialists in this? Over time, I came to the view that it's not a bug of the feature, it's of the system. It's a feature of it that's good, because what it requires, it requires of advocates that they speak to generalists, that they get out of their world and their use of jargon and be able to explain difficult things simply to generalists. So for advocates, I thought that was a good challenge. But more importantly, I came to the view that on these big, complex matters that have national impact, that it's actually good to have generalists do it, to have a generalist take a look at it and try and hopefully get to its essence, but be able to see it in a larger context. So you asked, so how do you do it? How do you do it? And the answer is with great difficulty. I found my first couple of years on the DC circuit to be really pretty overwhelming, because I didn't know. But my background had been with David. We did commercial litigation. We were representing insurance companies in environmental cleanup disputes. So we knew about state law involving, torts, and we knew CERCLA and stuff like that. But I didn't know any of this other stuff. And then I'm the general counsel of a university. That very few of those issues came to front of me. So how do you do it? You just spend a lot of time at it, and you just dive into it and try and do the best you can to make sense of it. In my first year or so, I was so anxious about this that I thought, I think I'll in the future hire one clerk who will just work on my FERC cases, and then I'll hire another clerk that'll just work on the Clean Air Act cases. Well, I never did that because I eventually decided that no, it's good for a generalist clerk to look at these things as well. I don't have any good answer for you other than you just take the time you need to get it done. I will tell you this story that I hope is helpful. I had been on DC Circuit for about 6 months or so. And it's a very collegial court, which was one of the great blessings of having been on the court. Your colleagues are wonderful people, get along really well, lots of interaction with them, lots of going to lunch with them and things like that. And one of the senior members of court invited me out to lunch, and I readily accepted his invitation. I knew him pretty well, and I felt that I could express to him my vulnerabilities. And I said, how do you do this? It's so hard. How do you do this? No, you come along in life and you have a certain amount of self-confidence that gets you on a court of appeals, and you're feeling pretty good about yourself, right? Yeah, things have gone well. And then you just feel totally inadequate. And so I asked him, I said, how in the world do you do this? And he gave much the same answer that I gave you. You just work harder, you work harder. But then he said, Tom, defer, defer, defer. Now, by that, he was teaching me a legal principle. That's an important one. We'll probably get to it a little bit later as well. Is that the case law is such, and the structure of government is such, that in many of the cases, that's what we're doing. We're just trying to make certain the agency hasn't gone crazy, right? And so that was actually pretty helpful to me. He also said something that was very discouraging. He meant it to be encouraging. He said, it'll take you 5 years before you'll feel comfortable with this. That was intended to be encouraging. I thought, I'm not going to tell you who this person was because I don't have permission to tell the story, but I thought if it took this judge 5 years to get comfortable with it, I'm not certain I ever will. But you do. You do. You just.
Well, so Judge, did on the issue of expertise, I mean, did it happen that different judges? I mean, I think Cheryl might say that over there at FERC, it's sort of like, well, this commissioner. I mean, you can tell me I'm wrong about this, Cheryl, but that one commissioner would would really devote a lot of attention to a particular area, and that might be kind of their area to focus on. And it's not like they get an extra vote because of that or anything, but it's really kind of their area of expertise. Did you find on the court that different judges would say, well, I'm administrative law or FCC or, I don't know, something else was really kind of their area of expertise, and the other judges would look at their view in a different way?
Yeah, no, I think so. I think that's the case. Now all our cases were assigned randomly. So it's not like a case came in the door and it was within the wheelhouse of a particular judge, so therefore she was assigned that case. No, they're assigned randomly. But no, you're working collegially, who has strengths. And since Cheryl's on the call, she won't be surprised because everyone knows this. We love Steve Williams, Judge Williams, who had taught energy law at the University of Colorado, right? I mean, and he loved the stuff and understood it. And so when you're on a panel where you've got a FERC case and Steve Williams was there, he had at least for me, he had an outsized influence. I was going to have to think really long and hard if I was going to end up disagreeing with him on something that he needs to. Well, and I've never done that. I've never gone back to see, was there an instance when Judge Williams and I were on a FERC case where I disagreed with him. But clearly he had, Senior Judge Ginsburg is an expert in labor law. And so, again, I don't think you ever just say, oh, I'm going to let him handle it. But that was a voice where when they spoke up and they had lots of experience in it, you listen to it. It kind of worked that way with me among some of my colleagues, although it shouldn't have. They assumed that I knew a lot more about congressional power and congressional prerogatives than I actually did. But when we would have those cases, they would sort of look at me like, you're the expert here. But I want to stress, never to the point where you just sort of delegate your decision making to someone else. But certain judges on certain topics, you knew they had expertise, and you'd listen.
I think that happened to an extent at FERC. It depended a lot who the chairman was, how much they wanted to share, um, kind of authority to run tech conferences and things like that with people who might deem themselves, or you have to earn being an expert in something. But, you wouldn't stay an expert very long if you're saying your cases to the DC Circuit and they all got flipped. Then
Well, Cheryl, over at the commission, you obviously had, I mean, different people would come there with different backgrounds. I mean, maybe it's gas, maybe it's electricity, maybe it's, whatever it is. So it would be sort of
some much
natural.
more
But then,
political and others
right,
much more businessy. Yeah.
right.
Um, yeah, and I've often said that, and of course they're not together as long as judges. So I've often said that FERC is not like the Beatles, where they kind of grew up playing music together and could listen to each other's cadences. They were more like the Monkees, where it's just like, okay, you guys be a band, and sometimes it works. While we're on FERC, and I'm going to take this little out of order from what we talked about, but I had
I was actually hoping you were going to do that because it plays right into
someone had
this
given
other
me
question.
as a gift the book Notorious RBG about Justice Ginsburg. And of course, the first thing I did was I looked in the index for FERC. And to my horror, it said that when she was on the DC Circuit, Marty Ginsburg used to make fun of her and call her the FERC judge because her cases were so boring, which somewhat deflated me, thinking this might have been a seminal experience for her. But I mean, how did you feel when all those dockets came over? And were there things that you liked about FERC cases? Were things that you kind of thought, oh no, not another?
Yeah. Well, no. So there's FERC is the butt of a lot of jokes in and around Washington, and on the DC Circuit. And I have to tell you, in the first couple of years, it seemed like I got a lot of FERC cases, and it seemed like there were a lot of rate making cases, and I just found those to be really, really difficult. I have to tell you, over time, I got less of the rate making cases and more of the other cases, and I found them. I can now say this safely because none of my colleagues are around. I actually enjoyed them. I thought they raised really significant issues about environmental justice, climate change, these sorts of things. I mean, energy law is pretty important, and so over time, I got more and more comfortable with it. The way that we do it on the DC Circuit is that in the conference with the three judges, when you've discussed the case and resolved the disposition, the senior most judge amongst the three has the prerogative to either take the first opinion for herself, and then the second most junior takes the second, and the most junior takes the third, or the senior most judge can make the assignment. More often it was the former, that the senior most judge would say, I'll take this case, and then the middle judge takes the next. And I have to say, I'm not certain that when I was senior most judge that I ever took a FERC case. I don't think I did. But when I was, even when I've been there quite a while, when I was
you were the junior person, you probably got stuck with them.
I was assigned a lot of them. But what I'm saying is, over time, I was less anxious about that. I was less anxious about that. So, but I'm not certain that I ever volunteered to take one. So,
Judge, I think that there was I remember a conversation you and I had a number of years ago when you were on the court. I don't know how many years you've been on the court at the time, but I was asking you about kind of what your favorite cases were, what types of cases you enjoyed the most, and which ones you thought were hardest. I don't think I phrased the question as which ones you hated or anything like that. But I remember, if I remember correctly, what your response was that separation of powers had always been a real area of interest of yours, that you really enjoyed those cases. But the cases you thought could be the hardest were the FERC cases and the Clean Air Act cases.
Yeah,
I mean, because the law was so complicated, the technology is complicated. A lot of the time, there's the fact it's just the economics can be very, very tough. That those were just hard cases some of the time.
Yeah, for me, that's exactly right. Those were I think I would add a third to the list, and that ended up being the Medicare financing cases. Those are really complicated as well. But I don't want to put rose-colored lenses on. There is a certain satisfaction of working through, as a generalist, complicated matters and feeling like, no, I think we got it right. I think we did the right thing here. So, but yeah, for me, those were the most challenging.
Well, let's, that may go right into kind of some questions about advocacy.
Sure.
The whole, I when I clerked a long time ago, on the 10th Circuit, not on the DC Circuit, but I think there was a case I remember where I read the record in the case, and one of the and it was after the argument, and one of the advocates had really done a great job in writing the brief and at arguing the case, and the other one, the brief was bad, the argument was bad, and yet after kind of reading it, I thought that the bad argument and the bad brief, that side actually should win. And I remember going and talking to Judge Logan there on the 10th Circuit, who I was clerking for, and I said, well, Judge, this one side, I mean, the briefs are terrible, the arguments are bad, but I said, I think that actually they ought to, and he said, well, and he could tell I didn't feel good about it. And he said, well, but doesn't it make you feel good to know that the facts and the law actually matter? And I think and yet the facts and the law matter, but good advocacy can matter too. I mean, what is it that you as a judge, what is it that you think, and particularly in these cases where the law is really complex, the facts and the economics are complex, what is it that kind of made good advocacy, and particularly in these cases where some of the time the energy lawyers can be accused of using too much jargon and too many acronyms and speaking in code? I mean, what advice would you have, or what do you think make good or bad advocacy?
A great question, and we could spend hours on it. And I think it's obviously central to any lawyers who are going to be in front of the DC Circuit. Let me start with the point that you made. No, it is the facts and the law, and the hardest part of our job as judges and the judges' law clerks were to try and understand poorly written briefs, right? Because you would. I mean, these people, this party deserves to have you give your best effort to this. And so a lot of time is spent on bad briefs, trying to understand what the argument is. At the end of the day, you're going to win or lose based on the facts and the law. But you want to make it as easy as possible for the judge, right? It's not a moot court. You're not deciding you win the case because you have the best brief. But great briefs can help you think about the case in a way, particularly in an area that you're not familiar with, in a way that helps you see what the law is and what the facts are. So I think the single most important thing that I found in good briefing was a summary of the argument that could, in 2 or 3 pages, maybe not even that much, that could frame the argument in a way to get me to understand what's going on, right? What is going on here? I don't know if other judges had this practice, but my practice was the very first thing that I would read when I picked up a brief was the summary of argument. And then that would be the last thing that I would read on the day that I was going in to hear oral argument. And in most cases, the first time I read the summary of argument, I really didn't have much idea what was going on. Hopefully, by the time I was getting ready to go on the court, I did, and I would go back to that on the bench, and I'd go back to the summary argument, and I could say, "That's it. There it is. There it is, stated plainly and clearly in a couple of pages what this case is about." So to me, the most effective advocate will frame the case at a high level of generality at the outset, that this is about these certain principles of law required by the statute, required by the law, frame it in a general way. In the summary of argument, dive down enough to let me know, what's going on in the case, but then to finish by convincing me that those high levels of generality are met by the law and by the facts. So to me, the summary of argument is critically important. The big challenge, we've alluded to several times, the big challenge is how do you explain complex matters to generalists? And my advice to brief writers is, and to people who are giving oral arguments, is you bring somebody in the decision-making process who knows nothing about the case, and you see if you can explain it to them in a way that they understand it. I once heard the Chief Justice say, in response to a question, who are you writing for? When you're writing your opinion, who are you writing for? And he said, I'm writing for my sister in Indiana. She's a college-educated woman, but she's not a lawyer. And I'm writing to her to explain what the case is about. And you look at the opinions of, I mean, right now we are really fortunate to have a Supreme Court that has some great stylists, right? Chief Justice Roberts, Justice Kagan, Justice Thomas, others, Justice Kavanaugh. These are all people who can write in a way that you actually don't need to have read the briefs to understand their opinion. So the big point is make it simple. And the way to figure out if you've made it simple and clear enough is you bring somebody else in who knows nothing about the case, and you explain it to them. And when you've gotten to the point that they understand it, then you're on the right path. To me, that's the single most surprising thing that I learned as a judge, is that the judges really are generalists. They do not know the case as well as you do. You have lived with the case for years, right? They have lived with it for weeks. And in some cases, they've only lived with it for days. And they're living with lots of cases. So you have got to make it just as plain as possible. And the best check to do that is to bring somebody else in who knows nothing about the case.
So can I ask?
How about oral argument? Could you have any advice for people on oral argument?
So the same idea. Moot it in front of somebody who doesn't know anything about it to make certain that they're following you. Yeah, lots of advice about oral argument. I mean, there's a rule in the DC circuit that you're not allowed to read. You're not allowed to read your argument. That's a bit unnerving, right? It's not always enforced, but it's a good rule. You don't want to be reading your argument. You want it to be conversation, right? If you can get away with this, if you know your case well enough, don't even bring notes, right? Yeah, maybe bring a 3x5 card to remind yourself that there are certain key points you want to make. But I found the most effective arguments were those that was very conversational. I did not have the feeling I was listening to a speech. I had the feeling that I was listening to somebody who was helping me grapple with an issue. Look, you have an ethical obligation to be a zealous advocate for your client, but that does not mean that you should be giving jury speeches or passionate defenses or arguments. To be a zealous advocate for your client, I think, means to be the most effective advocate you can be. And the way to be the most effective advocate you can be is to be conversational. Don't be passionate. I can't tell you the number of times when you hear a jury argument in front of the Court of Appeal, the panel, and then when we get back to the robing room, we just kind of look at each other like, roll your eyes. We've been working with the case. We know the case. We don't know as well as you do. What I will always hope for in an oral argument is that it was like having a conversation with a super law clerk who just knew this case inside and out, and who I could trust to give me the facts straight. Now, do not play around with the facts. Give me the facts straight. Then tell me what point it is, what 1, 2, or 3 points it is that require me vote for to side with your client. Or if you want to be really risky, this is I heard this from the Chief Justice. who was a great appellate advocate, as we know, he said that he thought the best advocates would identify the weakest point of their case, but explain to the judges why he shouldn't lose on that point. That's a little bit risky, especially if the client's in the room. I get that, but and so that's why everyone ought to use the first part of it, and that is identify the 2 or 3 strong points and get right to them. Don't give a speech, make it conversational, get right to the other stuff. Answer the question, right? And don't fight the hypothetical. Maybe we can discuss those later, but those are sort of common knowledge. The big one is just to dumb it down, make it simple. You will not offend any judge by making it too simple.
Well, that identify the weakest point, I guess, could depend on how weak that weakest point is. If there really is a sure guaranteed loser, then maybe you start with something else.
Yeah.
Well, so Judge, you mentioned a minute ago in terms of framing the argument about what's going on. Can you talk a little bit more about? Okay, so if an advocate is talking about what's going on, are you talking more about what's going on in terms of how your case fits into the legal structure, or what's going on with what is the practical import of the outcome of this decision in terms of that pipeline getting built, or these consumers having that gas, or
that's a good question, and the answer is both. What I'm primarily interested in, however, is the law, right? Teach me about the law in this area. What are the judgments that have been made by those who have authority to make them? What are they, and how do they inform this decision? To be sure, you want to work the practical side in as well, although I'm not one of those that thinks that one ought to place too much emphasis on that. I mean, look, Congress makes bad decisions sometimes, and the application of a statute to a circumstance may lead to an unjust result, may lead to a result that I don't particularly like, but I'm going to follow it anyway because that's what the law requires. Nevertheless, having said that, if the results are going to be disastrous, make sure the judge knows that. But what I was referring to primarily about how it works is the legal scheme. Let me understand where this fits in a larger picture in terms of the intent of Congress, Congress's purpose, Congress's intent, the agency's purpose.
Cheryl, if I can ask just one other follow-up on that.
Then I have one on this, and then one from Q&A.
Right. Okay. One of the things about certainly electricity cases are that the technology can be very complex. And I've seen different cases where the judges will I don't think I ever saw this in any opinion you wrote, but I've certainly seen it in opinions that other judges have written, where they scold the advocates for speaking too much in jargon, for speaking in terms of capacity and energy and VAR and NEM and DR and this and that and all this sort of stuff that for people who live in the electricity world, they know what it means, and yet it really makes it, for a generalist, and the judges will sometimes say, makes it very hard to understand. And yet I think that some of the time the advocates are doing that so that they feel like they're being precise. They're trying to economize on words, and they're trying to be precise. How much do you think that advocates before your former court or other courts should spend in terms of really making it, trying to explain about, okay, well, this is what we're really talking about here in terms of how this whole thing works, and going into a lot of that, and just what advice would you have for advocates?
So again, maybe this is just speaking about me. I like that framing. I want to be comfortable that I know the law in this area as well as you do, and so that's what I appreciate. I appreciate a framing that tells me, here's the big picture, and then now here's how this case fits within this. The DC Circuit has rules about use of acronyms. Be familiar with the local rules of any circuit court or any court. The DC Circuit has them about acronyms. So be familiar with those. And yeah, the jargon it can be deadly. It can be deadly. So try and avoid it. And we discussed the ways that you do that. You bring in generalists in your preparation to make certain they understand.
Judge, you've given a lot of advice for how to make sure the arguments are clear to a generalist judge. Given how much effort goes into that, we have a question in the chat. Do you think the courts would be better off assigning, as government has become so complicated, more specialized judges? Obviously we have a maritime court and I believe, various specialty courts, but not that have kept up with how specialized government has become. What do you think of that point?
Yeah, well, I think it's a good point. I think it's worth discussing and debating. I favor the generalist judge, and maybe there's some confirmation bias going on here, but I think there's a real value to making advocates dumb it down, make it. That's not the phrase. To keep it simple, right? To get to the essence of things, and when it's a bunch of specialists talking to each other, you don't need to get to the essence of it, right? So, for example, today I was on a call with a number of constitutional lawyers, and we were talking about the Dormant Commerce Clause, right? And none of us needed to stop and explain to each other what the Dormant Commerce Clause is, because we were all specialists. But if there was a generalist in the room, you would need to stop and explain that. Now, the good news is that can be fairly easily explained. And the nature of the enterprise that you're engaged in with the American judicial system, I think it benefits from making it plain and clear, forcing the advocates to do that, and then giving the decision to generalist judges who I hope, I know they're going to do the hard work to get it right, and then they're going to be able to explain it themselves in ways that the public can understand. Because it's not just the parties, right? And it's not just the industry that needs to understand. That needs to happen. It's also the public that needs to understand it. So maybe you just heard some confirmation bias. I think the system works pretty well, but I'd be interested to hear what experts think. If they think using generalists is leading to decisions that are just missing the point or getting the point.
Well, I'll see if our commenter comes back with a reply. I have a different question, though, that I wanted to ask before we left this good advocacy thing. You've talked about what makes a good brief, what makes a good oral argument. I know we have folks from FERC on the line and probably, hopefully, other agencies as well. What do you think makes a good order? Sometimes I've noticed some of the FERC orders, especially lately, the commissioners are answering all each other's arguments, but should they be talking to the court? I mean, were there orders that you looked at and said, what on earth is here? Or because
that's a great question. And since we're going to be reviewed, since that's going to be part of the record, right?
Yeah.
You want to make it as clear as possible. And the frustration that I would have on occasion is, once again, it's the same sort of problem. You have experts talking to experts, maybe not thinking or realizing that a generalist is going to be coming in and having a lot to say about the effect of this. So what I would look for and appreciate is when I could follow the order step by step by step. No leaps in logic. Each sentence follows from the sentence before. I mean, that's just clear writing. That's all I'm talking about. Just clear writing, but just recognizing that it isn't a dialogue just amongst specialists, that the nature of our system is you're going to bring these generalists in at some point, and they're going to have a lot to say about what you're doing. And so therefore, make it clear. So yeah, what I'm saying applies to everything an agency's doing, right? Because the way the system's set up is generalists are going to be reviewing.
David, I know you had a question. Yeah. David, I think you're on mute.
There we go.
Did you mute yourself?
That happens to me one you know, at some point in every session. You know, you'd think at
Whoever
this
had
point.
mute, you're on mute on their bingo card can check
Yes,
that
right.
out.
You'd think during this time of COVID time, you know, we'd all get that right every time, and I do at least once a session. So, you know, with respect to FERC orders, there a lot of and I realize there are actual legal consequences of this, but a lot of in the context of a FERC order, a lot of time is spent walking through the parties or what different commenters, different parties have said, or what their arguments were, and kind of walking through, you know, and so says this in their paper, and so says that, and the orders can kind of go on at great length about that. I mean, there's a part of that that's necessary.
Yeah,
but
yeah.
would you say that that you know, in any of the, or maybe you don't have a view one way or the other, that well, no, that they kind of get that just right, or wow, you know, geez, I mean, 100 pages of that is enough. You know, I didn't necessarily need to see that level of detail about some of that.
Well, I actually favor more detail rather than less when it comes to the facts. So some advice I got when I was early on the court from some seasoned colleagues when I was I did not clerk out of law school, so this was all a new sort of experience for me. So I was very open. I was very teachable, and and a number of my colleagues gave this advice, and this is something that Chief Justice Rehnquist used to stress a lot. He thought, and these colleagues of mine thought, that actually the most important part of the brief was the factual section, which I wouldn't have guessed that going in. But their advice was, no, the facts mean everything. Look, you know, we're going to be able to find that. We're going to be able to figure out the law. We've got these brilliant law clerks, and you know, we've got time to look at this. We'll be able to figure out the law. The really tough part is figuring out what happened. And we live at a time which I applaud in the federal judiciary, where the preference for most courts is to be minimalist, right? To confine decisions to the facts, so that, and now here's a separation of powers argument, so that you're not making broad pronouncements that have the effect of legislative. I'm a judicial conservative. I was a judicial conservative. I cheer judicial minimalism, and I found that most of my colleagues did as well. You don't want to decide more than you have to, right? And the way to do that is to know the facts of the case as best you can. So actually, in your hypothetical, David, I would say spend a lot of time on the facts. Now, the tough part, and this is where the creative part comes in, is what's necessary and what's not, right? But you're the one that knows the record, right? And I've got that record on my desk, right? But it's huge and it's daunting, and I need you in that facts section to point out to me what are the facts that I need to know to decide this case. And then, note of caution, you better get that right. Don't no. And it's surprising how often this happens, where a clerk would come to me and say, you know, they said that X happened. You know, I went to the record, and if you read 2 pages beyond that, it's not as clear. Don't do that. Don't play with it. You mean, if they're bad facts, get them out. Let me know right away. You know, it's like the White House, right? Bad facts. What do? You get out. You get out in the press as soon as you can.
You know, Judge,
let me know the bad facts. Don't hide them. Let me know the bad facts. And this is like the Chief Justice's comment. Tell me why they're not as bad as they might seem to be. So,
you know, Judge, you know, you're mentioning that story. It actually just reminds me one of the experiences that I had in clerking for Judge Logan. It's something I don't remember anything about what this particular case was about. I don't remember what the parties were. I don't remember whether it was a criminal or a civil case. But I remember reading a brief and looking up the case that they had cited, and it wasn't where they said it was. And once you have that sort of an error, you figure, well, they made that mistake. Is there, what else in here is there a problem with? And you know,
so you asked earlier about advocacy, and maybe I should have started this. The primary, you want the court to trust you. You want to be trustworthy, and I have to say, on the DC circuit, we have a lot of repeat players, right? And so they know that they're going to be back in front of us. They know that we need to be able to trust them, and I have to say, generally speaking, in 15 years I was on the DC circuit, the government briefs were by and large very trustworthy and very reliable. For those advocates who weren't repeat players and maybe representing a private interest, many of them did fine, but more often than not, that's where the problem would be. Government lawyers, and I would tell my clerks this. I said, by and large, you can trust the government lawyers on the record. Check it anyway, but you ought to go in. They've built up trust over the years. And
well, Judge, let me move to another interesting topic, or at least interesting to those of us that live in the administrative law world part of the time. The subject of Chevron and Chevron deference. There's been a lot of talk, I would say recently, but there's probably a lot of it can't be counted as recent anymore, about whether or not the Supreme Court ought to weaken or do away in some way with Chevron deference and the deference that Chevron calls for the federal courts of appeals to give to administrative agencies and agency decisions. Can you maybe talk just a little bit about that doctrine and just what your view was about it and about applying it, and what do you think the Supreme Court or your own court should do with it?
And defer, like your colleague said.
Yeah, can I start on a light note? The light note is, I love Chevron. I love Chevron. It makes a court of appeals judge job a lot easier, right? So that's a joke. It's a joke. No, I mean, books and hundreds of law review articles. This is a huge issue, right? And it comes out of, we have created the modern administrative state. You can have views on whether that's a good thing or a bad thing. I had some colleagues who thought the modern administrative state was a great leap, a great step forward in progress for the country. I had others who thought it was, a huge mistake. And I think your view about the administrative state and whether it's been a good thing for the country or not will have some impact on Chevron. Because what Chevron does, in effect, say is that Congress has created these agencies that are to look at issues that are perhaps too complex for Congress to deal with in detail, and we're going to create these agencies full of expertise. We're going to give them general guidance, and then as long as they stay within the lanes of that general guidance, the courts are going to defer. That's where the defer comes from. And the judgment you're making is that this is what Congress would have wanted, right? I mean, let me step further. In my view, the judge is in some ways a faithful agent of Congress, right? Congress creates the law signed by the president, and it's that law that Congress has created that the judges are supposed to use to resolve disputes. So you're always looking for, what did Congress do? What did Congress do? And the general idea behind Chevron is Congress can delegate to these agencies, and as long as the agencies are acting within the scope of that delegation, then Congress's congressional wish has been granted, and courts shouldn't get in the way. Now, just the way I stated, that's a highly idealized description of the way it works. And Justice Scalia, who originally was a defender of Chevron deference, by the time late in his life became a critic of Chevron deference, his criticism had largely to do with that's not what's actually taking place. What's taking place is that Congress is avoiding tough decisions because they want to be reelected, and so they're delegating too broad of authority to the administrative state, and it's the administrative agency that's really making the decisions. And here's the problem: they are not as politically accountable to we the people as members of Congress. So we have something askew in this system. We have folks who are not politically accountable making law. And so I think it's out of that impulse that comes this sense of, well, wait a second, maybe courts ought to take a more careful look at the nature of the transaction between Congress and the agency. And I'm completely in agreement with that impulse. These agencies need to be faithful agents of Congress. Now, here's the problem. What if Congress isn't really doing its job, right? And the agency has to act. That's where it gets really complicated. I think that's where a lot of the friction and the debate occurs, is whether Congress is doing its job or not. What does the agency do when maybe Congress isn't?
I mean, I think that's exactly right. And I've often observed that, a lot of these agencies are administering fairly old laws to very modern problems. I mean, we're using the Federal Power Act from, the Roosevelt era to apply it to cybersecurity and regional transmission organizations. And the EPA is trying to use the Clean Air Act of 1970 for climate change because that's what it has. Now, maybe that means if Congress hasn't acted, climate change isn't a problem and the EPA should try. But I think the agencies are trying to use what authority they have. And I mean, is that wrong? And also, I guess that relates to a question that came in the chat of like, obviously precedent is important, but what if an agency feels there should be a new interpretation of the statute? How do they go about making that argument? Because we are applying a lot of some of these statutes are older than I am, older than any of us are, to really cutting edge issues and trying our best.
And that relates, I don't want to get too wonky here, but that relates to the major questions doctrine, right? Which is has new life, pretty much a new approach. Like, can the agency really engage in such sweeping action based on a statute that doesn't seem to have that problem in mind at all? I mean, that's a cousin to this whole debate about Chevron. And look, there's no. I wish I had the silver bullet that answers this. In my mind, the problem comes with Congress. That Congress isn't stepping up to the plate and legislating the way it's supposed to, and then that gets to a larger issue. Why aren't they doing that, right? And there are all sorts of problems in that regard. It's hard to imagine in the present political environment with the intense polarization we have that we are on the verge of an era in which Congress will update statutes to address new problems, and so therefore I think the tension only gets greater. What is the agency supposed to do with this new issue? But I'm not good at making predictions, David. But I think most of the commentators suggest that this Supreme Court, is anxious to do something to send the signal that agencies shouldn't be engaged in as much legislating as they think it would. So I'm actually sympathetic to that. I don't know if that's what will happen, but you're getting that with the challenges to Chevron. I mean, obviously, Judge Gorsuch wrote about this a lot when he was on the 10th Circuit. Judge Kavanaugh wrote about this as well. You got questions with the major question doctrine, and now and also the whole non-delegation thing. So you have there's sort of three separate legal theories that are all at play right now. And I think what they all have in common is a frustration that Congress isn't legislating and anxiety about having agencies do that.
Well, and you know, the thing is about that, and again, as we're here talking about this today, Congress just a couple of days ago, of course, passed the big infrastructure law, which contains a lot of very important energy provisions in it. In a lot of respects is the kind of the most important piece of energy law, new substantive energy legislation to be passed since probably since the 2007 Energy Independence and Security Act. So, you know, Congress can certainly do it, but, you know, that piece of law, I think I saw that what Congress passed last week, I think it's in excess of 1,000 pages long. It has all sorts of stuff in it as to all kinds of things. You know, obviously everybody knows about how difficult it was for Congress to pass it. I do think that it seems to me on the whole Chevron deference point, it seems to me that good arguments can be made both ways, but if there isn't Chevron deference, therefore what? I mean, now what? You know, if the now what that is expected is, okay, well, now Congress will get back to passing substantive laws every other week. Well, I hope nobody's, you know, holding their breath about that. And yet, on the other hand, when you think about when Chevron actually was handed down by the Supreme Court back in the mid-'80s, well, I mean, that was obviously way before the internet. I mean, it's when substantive laws were, you know, enacted, at least, you know, occasionally. Well, I don't know if I should say they were enacted more frequently. I'm not so sure about that. But you know, it was a different time than today. So,
and I think, at least in my view, this is a big issue, right? And the big issue is it's a separation of powers issue. It's a fundamental issue. Are we comfortable as a people with administrative agencies making law? There are pretty strong arguments. I happen to favor these arguments, but that's not the plan, right? Maybe maybe if we were starting all over again, maybe that's a great plan, but that's not the plan we started with. The Constitution of the United States is based on a fundamentally different idea, and that is that the politically accountable representatives of we the people make the law. That's a really hard way to get things done. Have we discovered that the world is just too complex for that to work? Some people think we have. I'm not one of them. I think it's critical that we have politically accountable representatives. We the people make the law, and not experts who are not so accountable. That circumstance leads to, I think, lots of pathologies, some of which we're seeing.
But you've talked about the issues of partisanship in Congress, which is preventing a lot of laws from being passed. But as you know, there's been a lot of controversy about politicization of the judiciary and whether, you know, so if Congress can't make the laws and the judiciary is the one that's supposed to put a check on the agencies, and maybe the judiciary is becoming more political. Now, I used to hate it when I was at FERC and we'd send a case up and then immediately the trade press would report, oh, it's 2 Obama judges and 1 Bush judge, as if somehow that proved what was going to happen to the case. And I didn't think it did. On the other hand, when I look at the Supreme Court, which I know you've just been studying, it's hard not to see some politicization when you see the confirmation votes going on straight party lines, which is not how it used to work. So, I mean, how do you think about this? Did you notice a change in your 15 years on the bench?
No, I didn't. So I never once saw a single decision by a single judge when I was on the DC Circuit that I thought could be explained by partisan allegiance or affiliation or something. Not one. Now, I saw plenty of decisions that were made based on judges having different views about what the role of a judge is and how you read a statute and how you read the Constitution. Sometimes those map onto political views, but I think they're very different. I think they're very different. And I would actually come to the defense of the Supreme Court here, that that even in those 5-4 decisions, I don't see those as partisan decisions. I see them as judges trying to get the law right and having different views about what the law means. Look, like I wrote an opinion in one of the Affordable Care Act cases. It was the Halbig opinion. It was promptly overturned by the DC Circuit, and its reasoning was roundly rejected by the Supreme Court in the NFIB case. But the thought never occurred to me that any of those decisions were made based on whether people were for or against Obamacare, so-called Obamacare. If you read them carefully, they're based on how do you read a statute. And I took a view that was a kind of a narrow view of how you read a statute. Others took a view that you take a broader view of how you read a statute. Now, cynics will say that judges are just using those arguments about statutory interpretation to cloak their real motive, and that is they want to advance their favorite political cause. I reject that. I reject that flat. It never happened on the DC Circuit unless I was just completely blind to it. And I don't believe it happens on the Supreme Court either. What you have is different views about what a judge is doing when she's reading a statute. And so therefore, and I think the language of politicians that suggests they are partisans is not only inaccurate, I think it's damaging. It undermines trust in our institutions. And as Jonathan Haidt, the social psychologist at NYU, the author of The Righteous Mind, said recently, we just don't know what happens to a democracy when you drain all trust out of the system. So when President Trump dismissed an opinion that went against him because it was rendered by an Obama judge, remember, within a day, wasn't it? It was immediately, the Chief Justice did something extraordinary and disputed that, said, we don't have Obama judges, we don't have Clinton judges. We have judges doing their best to apply the law. In fact, I can remember, I was actually driving at that time. I pulled my car over and I sent him an email saying, bravo, bravo. So yeah, I like others, I bemoan what's happened to the confirmation process. Look, Justice Barrett's a friend of mine. I cheered her appointment. I think she's a great justice. I think she will be a great fit. But her confirmation hearing was all about the Affordable Care Act and whether it's a good thing or not. And to me, that's just such a cynical view of what judging is about. And I reject it flatly. I just think it's wrong, and I think it's dangerous.
Well, so Judge, can I, further on the issue of really who has what power, and going back to a conversation we were having just a couple of minutes ago about the power of agencies, power of judges, power of Congress. I mean, one of the things that a lot of the folks who deal with independent agencies like FERC or the FCC or the SEC, different independent agencies, a lot of folks may not know that much about what exactly gives independent agencies the independence that they have. And of course, it's the words of their statute, but it also is the decision of Humphrey's executor back in the 1930s, where the Supreme Court of the United States actually rebuffed FDR's attempt to fire commissioners, Humphrey, one of the commissioners at the Federal Trade Commission. And they said that, well, no, you can't do that just because you don't like his decisions. They're under the statute that one of the FTC commissioners can only be removed. I think the words in that particular statute are for inefficiency, neglect, or malfeasance in office.
Yeah.
And thereby gave rise to really, I mean, that's really a cornerstone of the administrative state, to the independence of the independent agencies. And yet there have been questions raised about that, including by now Justice Kavanaugh in the Aiken County case a few years ago, as to really the constitutional grounding for that, and whether or not it was really properly decided. I mean, and whether there was whether the executive power really ought to be, even with what we think of as the independent agency, should really be subject to the control of the president. And do you have any thoughts about that? Kind of
I do, and I've actually written about it. I wrote a concurring opinion in the, I always get the acronym wrong, PHCB, PCHB. It was looking at the constitutionality of the consumer, the CPFB or whatever.
The double layer one.
Yeah, no, it wasn't. It was, it was. And Judge Kavanaugh dissented. I wrote a concurring opinion. Look, when you're on a court of appeals, you can't say overturn Humphrey's executive, right? You can't do that, right? That's what they get to do at First Street, but you don't get to do that on a court of appeals. So when and when I looked at the history of Humphrey's executor, I came to the conclusion that the four cause provisions gave the president a lot more power than subsequent case law decided. So in that way, I guess my opinion is a bit of a dodge. But I think Humphrey's executor is not on a firm foundation, shall.
Mm-hmm.
And again, let's go back to first principles, right? And I subscribe to the unitary executive. I don't think there's a unitary executive theory. I think that's what the Constitution does, right? That the president is in control of the executive branch. And so the idea of independent agencies, I know it's established in law, and you got to follow it when you're on the DC circuit. But as you know, there are a lot of people wondering if that's really the right way to go. And the Supreme Court suggested they may look at ways of carving it back, if not overturning it. And I think Humphrey executor is highly suspect and is not a firm foundation, because it departs from this model that, look, when I speak to law students and college students, I sort of my standard stump speech is to say, the Constitution of 1787 really wasn't much about rights. I know there's some rights in there. That's important. It's important. But it wasn't primarily about rights. It was primarily about who decides. Right. Judge Jeff Sutton, greatest living judge. He's just a fabulous judge. Is writing a book on this right. And the point is, who decides? That's what the framers were really interested in. Who decides? Now, fortunately, we do have rights as well. We fought a war over some of those rights. And we've got the Bill of Rights, we've got the 13th through 15th Amendments, 19th Amendment. Don't get me wrong, I'm all for those. But in the first instance, the Philadelphia Convention in 1787 was about the decision, who decides what? And the problem with Humphrey's executor, in my view, is that it departs from that original plan. And anytime you depart from that original plan without amending the Constitution to do so, I'm very nervous. I'm a judicial conservative. I favor going back to that original plan about who decides. And I don't think Humphrey's executive takes that into account. And it was decided by a court. I think their reasoning in a lot of those who decides issues is suspect.
We have a question in the chat I'd like to take. We've talked about, you know, how advocates should write their briefs, how agencies should write their orders. What about Congress? Are they using too many words that are too easily open to judicial interpretation with everything reasonable and so forth?
Yes,
setting
yes,
it up
yes.
to fail? Yeah.
Yes, and a certain amount of that is required. I mean, you know, because
Yeah.
they can't micromanage, you know,
Yeah.
what clean air is. But to say in creating the FCC that it acts in the public interest, I mean, that's just a delegation of authority to the agency, right? And then who's going to resolve it? Then the courts. Well, neither the agency or the courts are politically accountable bodies, right? They're not in the same way that the Congress is. And this was Justice Scalia's criticism, right? He was not a big fan of the work of Congress, and his point was, look, they're legislating in these areas so they can go back to their districts and say, you know, I'm all for clean air, but they haven't given any direction. And the game, according to Justice Scalia, and I think he's probably right on this, the political game is, you say, we legislated for clean air, but then what you really did is you just gave a lot of authority to the EPA, and then you sit back and watch what they do. And then if you don't like it, then you attack them, right? And so that's no way to run.
Well, now I don't know.
You talked about other judges writing a book. I would read yours.
But now Judge Cheryl might have actually liked that authority when she was over there at FERC. You know, the words just and reasonable and unduly discriminatory. Those are
hardy plans for many decades.
Yeah.
But public interest and not inconsistent with the public interest got people really tied up in knots sometimes.
There you go. Yeah, yeah.
But what would be done about that, really? I mean, nobody can make Congress pass a law. Nobody can make them do it. If the agents is the answer to that, Judge, well, you know, the answer is, well, I guess it'll get bad enough. And at that point,
I don't know the answer, David. I don't know the answer. It's just that under the current system, we're creating, as I said before, pathologies where the people who are making the decisions now are unelected people in robes, right? That's not good. We didn't. Maybe Plato was right. Maybe it would be better to have a world that's run by wise men and women. But that's not our system, right? Our system is we, the people, make these decisions through politically accountable representatives. Right now, too many of those decisions are being made by people in robes who have life tenure and are not politically accountable, or by experts who are insulated from we, the people. Well, that's not the system. I think we're.
Well, I completely agree with you. I mean, I think and then the elected officials just complain. You know, like as you were saying, I mean, it's easier to complain about what the executive branch and Cheryl's old agency.
While we're passing around blame, I don't think all the blame rests with Congress. I mean, they're being responsive to what the electorate wants. So if you want to talk about blame, you know, we the people aren't stepping up.
Yeah, and I've noticed that there is kind of a proxy for we the people. Like, for example, when they were having the kids kidnapped from their parents at the border, I mean, it just got so intense that it was clear that a lot of people were upset that policy moved a little bit. But that's just at the edges when something is so galvanizing of the public body in the kind of public square. That's not, you know, you're not going to see people revolt about whether FERC, what social cost of carbon FERC uses, or some of these decisions that the judges are making. But
that gives me a lead into the theme I've been sounding before I stepped down from the bench, and since then have been writing about it. You know, this is a perilous moment in the republic because of the political polarization, and anyone who's involved in that polarization just needs to stop. When one takes a careful look at what happened in the Philadelphia Convention in 1787, you learn that the animating spirit of the Constitution is the spirit of compromise, is the spirit that seeks to unify. Those delegates compromised on some very difficult things for them. They did so for the sake of unity. And so if you want to say that I'm a supporter and defender of the Constitution, and we all want to be that, as important as the Second Amendment is, and I've written some Second Amendment opinions that the NRA loved, but as important as the Second Amendment is, as important as any of the amendments are, we miss the forest for the trees when we miss that the animating spirit of the Constitution, the structure of government that it creates, demands compromise. It demands it. It forces it, because the judgment is that compromise for the sake of the public interest is a good. The word virtue was used a lot in the 18th century. It didn't mean to them quite what it means to us. Virtue to them, as I'm told by scholars, meant the common good, the public interest, and that's the really big picture of what's going on. I think what's besetting us right now is that we're not enough people are willing to compromise for the public good, and there are a million causes for that. But back to my stump speech in front of law students is get off cable, just stop it. Just stop it. Cable, if you're getting your news from cable and social media, you're being played, right? You're being played. Arthur Brooks calls it the outrage industrial complex. That's not where you got to be getting your information from, because you're being played. We're in a tough spot. We need people who are well-informed and who are willing to compromise for the public good.
So, Judge, let me.
It's a long way from Chevron. I get it. I'm sorry.
No. That's terrific.
Yeah.
I very much appreciate all of your comments. Well, so we've only got a few minutes left, but I'll tell you something I think folks would really like to hear is a little bit of. You've had of your career advice. You've had an incredibly distinguished career yourself.
It's still continuing in its distinguished fashion.
Right. I say you've had as if it's over. No, you're continuing on. You have had and are having an incredibly distinguished career, and of course have hired a number of outstanding law clerks through your career on the court who are going on to distinguished careers of their own. I mean, what sort of what advice would you offer college students or young or law students or just young professionals for career?
It's not going to be any rocket science here. When my law clerks would come to my start in chambers, I gave them a gift. I gave each one of them a plastic turtle to put on their desk, and the turtle was sort of a mark of a promise I made to them. The turtle is a common motif up at the Supreme Court. They all wanted to clerk on the Supreme Court, and it was my pledge to them that I would do everything I could to help them realize that dream. And fortunately, we succeeded many times, which is great. But the turtle was also a reminder to them to go slow and to be careful. And all of the mistakes I've made in my career, and I've made some huge mistakes. David's been witness to some of them. Have been when I moved too quickly. When I was too embarrassed to tell my supervisor that I needed more time to answer this. Because you always want to say, oh yeah, I've got this, it's easy. But the big mistakes I made all came when I was too proud to say I need another day, and then I made a mistake. Now sometimes I lucked out and I got it right, but the big mistakes I made all have that in common. The flip side of that, the good things that I did, and I've done some things I'm very proud of, all came about because I took the edge. Because I was willing to push the partner back a little bit or the senator and say, I need a little bit more time on this. And I found that when you take the extra time that you need and you get it right, they forget about the time. They forget it. So that's the first thing, is just do really good, careful work. It was said of Abraham Lincoln by his law partner, William Herndon, that he didn't have a quick mind, but he was a careful study. I wish I had I wish I had lots in common with Abraham Lincoln, who I idolize, but I don't. But I do have that, right? I'm not a quick study, but I can be a careful one. So be a quick and careful study. The second one, be nice to people. No, seriously, it's really important that you treat people with dignity and respect. First of all, because it's the right thing, right? But let's imagine for a second that you don't care about the right thing to do, that the only thing you care about is you. Well, I pity your shriveled soul, but let's imagine that's who you are. If the only person you care about is you, I'll tell you the best thing that you can do: be nice to people, because you have no idea who that person sitting next to you is going to be in 10 or 15 or 20 years from now. And they may be making a decision that has a big impact on opportunities that come your way. And at that point in time, you want them to think, she was really nice, right? She was really nice. So those are my two bits of advice. Work hard, be careful, be slow, get it right, but be nice to people.
Those are great pieces of advice. Cheryl, any last words before I close it?
Yeah. In our closing question here, you mentioned there are some things you're proud of. As you look back at your 15 years on the bench, what are you most proud of?
I am most proud of the decision I made in the Shelby County case to uphold the Voting Rights Act of 1965. We were overturned by the Supreme Court. We knew we were going to be overturned by the Supreme Court, but I was not going to be on the first panel of federal judges to overturn what I thought and think to this day is the most significant piece of legislation in the history of the country. First of all, I think as a legal matter, it should have been upheld. I think Congress did enough work to justify, to be sure, the onerous involvement of the Justice Department in elections in mostly in the South. That's a big burden. But we fought a war over this. We had an amendment to the Constitution that guaranteed the right to vote to African Americans and then later other minorities. And I was proud to cast the vote that upheld that, even though it was going to later be overturned. So by far and away, that was my proudest moment.
Thank you.
Sorry it wasn't a FERC case, Cheryl. Sorry it wasn't.
That's okay.
But those might be second or third on the list. Well, Judge, again, on behalf of Columbia, the Center on Global Energy Policy, and Cheryl and myself, I just want to thank you again for joining us today. We've greatly enjoyed the conversation with you.
Thank you. I enjoyed it too, and I hope it was helpful in some way to somebody.
Good. Absolutely.
Really terrific. And I want to thank our audience for joining us as well. As we mentioned at the beginning, the full video recording of the event will be available on the Center on Global Energy Policy's website in a few days. The Center's next event, the second session of the Columbia Energy Tech Revolution Forum, will be held this Wednesday, November 10th at from 10 to noon Eastern. The discussion will focus on new battery technologies. And also for a full calendar of upcoming events, you can visit the Center on Global Energy Policy's website. We hope you enjoy the rest of your day, and we look forward to seeing you again soon. Thank you.
Thank you so much, Judge Griffith.
Thank you.